Hello, this is Celeste Miller. I am the statewide Kinship Care Legal Aid Coordinator for Washington State, and this is a recorded presentation for Kinship Caregivers about the new Minor Guardianship Law and some information about non-parent custody cases and non-parent custody orders now that we are in 2021. This is recorded on January 11th, 2021, and it's available on the Kinship Care Legal Aid Coordinator's YouTube channel. First, I wanted to introduce myself for anyone who doesn't know me. My name is Celeste Miller. I started in this position in September 2019, a little over almost a year and a half ago. Before working here, I had a solo practice. I did family law with a sliding scale, and I am the past chair of the Low Bono section, which is a group of attorneys in Washington State who offer sliding scale fees and are dedicated to improving access to the legal system. I also went to law school with the specific goal to work in legal aid, which is legal services provided for free to clients who need them. Before law school, I received a master's in social work. And so for a long time, I have just really wanted to work with families and help them. Also, my office is in Seattle, but my job title and my duties are statewide. So nice to meet you. Also, okay, to clear up some things about what I do and what I do not do. What I do is create resources for attorneys so that they can help kinship caregivers. That can include pro bono volunteer attorneys and low bono attorneys who offer sliding scale or other affordable options. I also work with volunteer lawyer programs to help them set up more legal resources for kinship caregivers. Another area I work in is in collaboration with kinship navigators through DSHS to provide resources and connections to legal help. And I create trainings like this and written materials for attorneys and also for kinship caregivers themselves and for kinship navigators. What I don't do is I don't take individual cases. So I don't have clients. I don't go to court on guardianship cases. That's not a part of my specific job. And if I'm contacted about a person's situation, I can't give specific legal advice about that person's situation, but I can send information and resources regarding how to find legal help or how to find advice, either for representing oneself or finding an attorney for help. All right, so this is my first video that I have made, and the outline is that first I'll talk about what is happening to non-parent custody cases in the state of Washington and what happens if you have a non-parent custody order already. How can a non-parent custody order be modified in the future now that it is 2021 and the non-parent custody statute is being repealed? This will also cover a broad overview of the new minor guardianship law in Washington, and including what I've got on these slides, such as who can file a case, what the parent's rights are, what the child's rights are, what the duties of the guardian will be, who you have to serve notice of a case, etc. Okay. So, as as I said, I'm recording this on January 11th, 2021. We're in a time of transition. The new minor guardianship law went into effect on January 1st. So it's very new and we've been trying to prepare for it, but everyone is kind of in the same page, same place, figuring things out as we go. What we do know, you can file a minor guardianship case. They have begun. The law is RCW 11.130, specifically Article 2, which you can find online. And there are forms that were created by the Forms Committee. They are not required, but you are welcome to use them. They're at the Washington Court Forms website under the minor guardianship section. So be careful when you go there because there is a guardianship section that's not the same as minor guardianship. Also, you can find some packets on washingtonlawhelp.org, I believe, under the Family and Safety Guardianship of a Child section. Those include how to file a case, information about rights of the child and parties in these cases. They will also probably be putting new ones up, so make sure to double check there at times. And finally, on this slide, I've included the free training for guardians. It's not how to file a case, but it's what you are required to do when you are a guardian for a child. And that is available on the Office of Public Guardianship's website. Okay, so starting with the non-parent custody cases. This is a Washington state law. It's 2610. The new Uniform Guardianship Act repeals this law and the minor guardianships replace the non-parent custody cases. However, right at the end of 2020, our governor signed an emergency proclamation to extend the non-parent custody law until January 30, 2021. The reason that he did this is so that courts and people with non-parent custody cases can finish their non-parent custody cases. So some counties were being very strict with the deadline and saying if you were not done with your non-parent custody case on December 31st, 2020, then it was getting dismissed and you had to start a whole new guardianship case and start over. So that is not the situation anymore. At least until the end of January, you have more time to finish. If you have an open case, that means you started a non-parent custody case, but it hasn't finished yet. You didn't have your trial yet, or you didn't get the agreed papers signed off. It's not finished. Every county also in the state of Washington may be doing these cases a little bit differently. So it's really important to check with your county's Superior Court clerk's office, check their website, find out what their rules are for finishing your non-parent custody case. Some of the counties are allowing longer time than 1 month. So just depends which county you are in. And if you don't have a non-parent custody case, but you wanted to start one, that can't be done. So at the end of 2020, the ability to file a non-parent custody case ended. The governor's proclamation only extended the non-parent custody law to be able to finish these non-parent custody cases. The proclamation has a specific section about how you can't start a new case in 2021. So if you want to start a new case and get custody, AKA guardianship, of a child, it must be the new minor guardianship case now. So what if you have non-parent custody already and your case is finished and it's been finished for a while and you are concerned about what's going to happen with this new law? Okay, if you have a non-parent custody order that's a final order, so your case, you either had a trial or you had agreed orders and your case is done, then your non-parent custody order remains valid. So you still have custody and that cannot be changed except through going through another court case. In this slide, I put an example of what the caption looks like on a non-parent custody order. So if you want to double check if your order is final or if it's temporary, look at your order, look at the first page. It should say final on it. It also should be signed by a judge. So sometimes people have a draft of their documents, but it's not the court, the final one that's in the court records. So make sure your order is signed by a judge and make sure that it says final on it. If you have that, you still have custody. Nothing has changed with the year turning over to 2021. Okay, so if you have custody through non-parent custody and you're worried about how, is this changing? What does the new law do to this? The only way to change your non-parent custody order going forward is for someone to file a petition to terminate or change the minor guardianship or non-parent custody order. So that form is in the list of forms on the state court forms website. And even if you have a non-parent custody order, the new guardianship law applies to the non-parent custody order when anyone wants to change it. So if, say, a parent wants to regain custody of their child, they would have to file the petition to terminate the non-parent custody order in court, and they would have to serve you the papers, and you would have a chance to respond, go to court, etc. The judge would decide. Or if everyone agrees that it's time for the child to go and live with their parents, you can terminate a non-parent custody order by agreement. You still have to do some court paperwork. If you do not agree, and when I say you, I'm speaking to Kinship Caregivers in Washington State. So this video is for people who are guardians or non-parent custodians of a child who is a relative. So when I say you, I'm not talking to parents, I'm talking to people who have gained non-parent custody or guardianship. So if you have custody and you don't agree with the parents that it's time to change custody or terminate the custody agreement, then you would have a contested case and the parents would have to show the judge that the reason the guardianship or the non-parent custody case started in the beginning, that those reasons are gone, that they no longer exist. So they have to have clear evidence that whatever the reason they lost custody in the past is not a problem anymore. There are a few other things that the court can do, even if in terms of terminating guardianship or a non-parent custody order, and I will go through those in a little more detail later on in this training. So The new minor guardianship law, that is, that's all I'm going to talk about in terms of non-parent custody in this video. And so we're moving on to the new law. As mentioned before, if you want to read the law, it's RCW 11.130. And there's an Article 2, that's what you would read for minor guardianship. This law was proposed and approved in 2019 by our state legislature, and some amendments were made to it in 2020. And it went into effect, well, Article 2 and some other provisions went into effect on January 1st, 2021. So we're live. Other parts of the law, which are in terms of guardianships of adults, so this doesn't really apply for kinship caregivers. That section of the law does not go into effect until 2022. So that's why I differentiated. Minor guardianships are live. Okay, in these cases, there are multiple different people who can file the case. So first, a person who wants to be the guardian. So that's probably going to be the majority of cases, is when someone wants custody, guardianship of a child, and they file their case. Other options for who can file this include the child who wants a guardian. So they can do that probably with an attorney through a nonprofit or a legal aid organization or something like that. And another option is that a minor guardianship petition can be filed by a person who believes the child needs a guardian, but does not want to be the guardian themselves. So they could file the petition and say, I want my cousin to be the guardian of this child. And how much does it cost? There is no filing fee for the petitioner, the person who's filing the case. There's no filing fee if the guardian is related to the child, and they're not a professional guardian. So I believe the majority of petitioners in minor guardianship cases going forward will not be professional guardians. They'll probably just be relatives of the child who are trying to ensure the child's safety. So if you are a relative of the child you want to be the guardian of, there won't be a cost, which is nice because non-parent custody cases cost $260 or so to file, unless you got a special waiver. When you file the case, you have to serve people. Now in this new law, there's 2 levels of service. There's tier 1, we're calling it tier 1, and that's who is required to be personally served. Personal service means the papers are just handed to that person by an adult who is not involved in the case. So if you are filing for guardianship, you cannot be the one who gives the papers to the parents or the other people who are required to be served. So as you can see on this list, the parents of the child are included. The child, if they are over 12 years old, there is a special order from the court you can request to not serve the child. And I will probably do a video more specifically about that soon. Also, if there is a current legal guardian or non-parent custodian, you have to serve them the papers. Then there's a whole other tier 2 notice, which is a list of people who you must give notice. That's different from serving. So this can be sent to them in the mail. It can be sent to them in some way that is reasonably calculated that they will actually get it. So that could potentially be email, but I would recommend talking to an attorney before you do anything besides just mailing it to them in the mail. So this list of tier 2, there is a possibility to ask to not have to send somebody on this list the papers if you think it would be harmful to the child. And that's another thing that I'll include in a specific video about notice later on. So this list includes any adult who has care and custody of the child if they're not the parent or legal guardian already. Also, anybody who had custody of this child in the last 2 years for longer than 60 days, and or anybody who had custody, aka was taking care of the child lived with them for longer than 730 days, that's about 2 years, excuse me, during the last 5 years. So when you're filling out these papers, you really have to think about where this child has lived for the last 5 years. Other people on this list are grandparents, both sides. They need to be sent copies of the paperwork, and adult siblings of the child if they have any. So if you go to the Washington Court Forms website, which is on the slide, and it's also courts.wa.gov/forms, and you look under minor guardianship, and you look at the notice of hearing about a guardianship petition, at the bottom, it has an attachment, and it has this whole worksheet where you can fill out everybody who is required to get these papers. So this will help you make sure you're not missing anyone, and just be prepared for when you're filing the case. And I don't know if I said this before, but the forms, the court forms on this website are all free. So you can go to the website, you can download them in a Word document, so you can type and fill them out on your computer, or you can download them in a PDF, print them out, write on them, etc. Just have to make sure that your handwriting is legible. Okay, more questions with answers. Do the parents get free attorneys in the new minor guardianship cases? There is one situation in which the parents do get court-appointed attorneys under this law. That is if they meet 2 requirements. One, they're indigent. That means they are low income or no income below a certain level that qualifies them for a public defender. And 2, if they object to the guardianship. So, and the free attorneys, it sounds like, most likely are not going to be public defenders. They're going to be private attorneys who sign up to be on this list. This will also vary by county, whichever county you live in. So if the parent is super low income, but does want you to be the guardian, they probably won't have a lawyer signed up for them. It's only if they do not agree to the guardianship and they don't have enough income to qualify for, or they are low income enough to qualify for a free attorney. There is a part of the law that says if the court thinks that the parent needs a lawyer, and even if the parent is not indigent, the court can appoint one. So the important difference is that the court may do it instead of the court shall do it. And this situation could be in terms of, someone who is not competent to make decisions on their own or something like that. It's not a requirement, and it's going to be a lot less likely to happen. Also, of course, if the parents have funds, they can hire a private attorney. There's nothing saying they can't do that. Does the child get an attorney? So under this new law for minor guardianships, there is an option for the child to be appointed a free attorney by the court. There's no requirement for it. The law says it may happen, so very different than shall. And that situation is a couple of different situations. If the child is 12 years old or older and they ask the court for an attorney, the court may appoint them one. If there's a guardian ad litem and the guardian ad litem recommends that the child have an attorney, the court may give them one. Or if the court decides all on its own that the child needs an attorney, the court may appoint one. None of these are requirements. Also, the law says that the child can have their own attorney, which would probably be someone from a nonprofit or a volunteer organization. So it's possible, it's not guaranteed. The child does have other rights in these cases. First, they have the right to be served the paperwork from the case if they're 12 or older. There is a process for the person filing the case to ask the judge to let you not give the paperwork to the child if they're over 12 and they don't have a lawyer. That would be if what's in the paperwork would be, harmful to the child. If the child has a lawyer, you have to serve it to their lawyer. If the child does not have a lawyer and the court lets you keep some of the information back from the child does still have the right to request the court to let them look at the paperwork. So they will be told about that right. They may or may not ask to see the paperwork. And this is all for if they're over 12 years old. If they are under 12, you don't have to serve them the paperwork. Other rights that the child has is to attend all hearings unless the court determines that they lack the maturity or emotional maturity to come to court, or that it would be harmful for them to be in court and hear what was going on. That's the court's decision. The child has the right to participate in the case. That means they, and through their attorney, probably can file declarations, say who they want to be their guardian, things like that. And they also have the right to have a court visitor, which is a non-attorney who'd be appointed to the child if they don't have a lawyer. And the court visitor talks to the child, does an investigation, and writes a report to the judge about what the child's views and positions are. So that's not the same as what's best for the child. It's basically what the child wants is what the court visitor will report. All right, so you're filing a guardianship. What do you have to prove to get the guardianship approved and to be appointed as a guardian of this child? So there are a couple of different things you have to show. You have to show that it's in the child's best interest to have a guardian. And the main one, if the parents do not agree, is that you have to show that no parent of the child is willing or able to exercise parenting functions. Excuse me. So the law that they're talking about that defines parenting functions is called 26.09.004, and it includes things like attending to the child's needs, the child's education, the child's development, ensuring their safety, helping them in their relationships, and supporting the child financially. That's not an entire list, so you can look up that RCW, that 26.09.004, and see what parenting functions are in terms of showing that the parents can't do them or are not willing to do them. And you have to show this with clear and convincing evidence. That means the evidence has to be very strong for the judge. It can't just be probably the parents can't do it. It has to be, we pretty much almost convinced you these parents cannot take care of the child. All right, the other two ways to have a guardianship created would be to show that the parents' rights have been terminated. So that would be done by the state after a CPS case and a dependency case, or potentially through an adoption. So that's also somewhat rare. Or the other way to have a guardianship created is if the parents agree with you and everyone agrees and fills out all the paperwork and it's signed by the court. All right. So now you have become the guardian. You prevailed in your case. What are your rights and responsibilities? So under the statute, your rights and your responsibilities include anything a parent would be doing for a child in terms of taking care of them, putting them through school, ensuring their health, safety. You have custody of the child. You can consent to their health care. You can manage any of their funds, apply for benefits for them, spend money that's in trust for them if that applies to your situation. Please note that there is a part of this law called conservatorships, which can be applied for if the child has a lot of assets. So, sometimes a child could inherit a lot of money and it's in a trust, or a child could have funds from a settlement. So you would manage those, or if it was a lot, you would apply to be a conservator as well as their guardian. The other right that you would have would be to consent to adoption of the minor, but that's only if their parents are not alive. So even if you are their guardian, well, I'm not going to get into that. It's too complicated, but I'll talk about it when I do a video on adoption. Okay, thank you. Moving to the next slide. How can the parents get custody back? This is a big question that I get very often from kinship navigators and from kinship caregivers. So I talked a little already about how to change or terminate a non-parent custody order in the future. It's the same process for the guardianships. So if there is a guardianship, you've got it created, you are the guardian. The way for it to change or to be canceled or terminated would be if the parents or another party files a petition to modify or terminate the guardianship. They have to show that the reason for the guardianship no longer exists. And just like I was saying about non-parent custody, this means that the parents, usually it's the parents, that's, they they have to show that whatever was going on that caused them to lose custody has been resolved and is not happening anymore, and that they can take care of the child. Now, the law says that even if the parents show that these reasons that they lost custody are resolved, the court could keep the guardianship if it finds that terminating the guardianship would be harmful to the child, and also the child's interest in staying in a guardianship is stronger than the parent's interest in getting their rights, their decision-making rights back about the child. So that is what the law says about terminating a guardianship. Now, does the Indian Child Welfare Act apply? This is a federal law, and every state has a state version of this law. And this does apply in minor guardianships. So it requires that anytime there's a custody case or a case involving a child and changing where a child lives, including CPS cases, that the people involved have to try to find out if the child is a member of a tribe or could be a member of a tribe. And if so, they have to send notice to the tribe. The tribe then could respond and move the custody case, to the tribe's court, or they could say, we want to be involved, but we'll leave it in the state court, or they could just not respond and not get involved. Those are kind of the main things that happen. So this is something that is important, and you need to be aware of it when you're filling out the forms for the guardianship. There is a whole section on the form that asks about this, so don't gloss over it. Try to find out if there's any way possible that the child could be a member of a tribe or could be eligible to be a member of a tribe. And if they're not, and you absolutely know that, you can say, no, they are not. And then this doesn't apply. All right. Okay, if you have a guardianship, is there a parenting plan? Can parents have visits? Yes, there can be a visitation schedule, and it's not required, but there can be one, and the visits can be restricted or supervised based on what's going on with the parents, and if the court, agrees with you when you're asking for these restrictions. Can you get child support? Yes, the Minor Guardianship Law says that parents can be required to pay child support to the guardian, and that would also be calculated and set up at court when you are getting the guardianship established. So those are important things to know as well. Can you get a protection order? Yes, but you have to apply for it separately from the guardianship. So in a regular guardianship, on the form when you are filing the petition, it has a section that says, do you want a protection order? And if you do, you can say yes. And then it says, be aware that you also have to file a petition for a protection order at the same time. So it's more paperwork, but you can do it and have it linked to your guardianship case. There is also another type of guardianship under the new law called emergency guardianship. And I'm going to do a separate video on this that's more in depth just on emergency guardianships. But for the short version, it's a short-term emergency guardianship. It only lasts 60 days, although it can be extended one time. And it's what you would apply for if you needed the emergency custody of the child before the whole case goes to court and everything. So that would be if you needed custody of the child like within the next few days and you had evidence that the child was in potential danger. More information about this. So as mentioned, it's a separate case. There's a form specifically called Petition for Emergency Guardianship. So it's a little bit different from the regular minor guardianship. The way that you get this is by showing a judge that there's no other person besides you who is able to take care of the child and willing and able to take care of the child right now. And that if you are not appointed as an emergency guardian, the child's health, safety, and welfare could be in substantial danger. So, like I said, I'll make another video that's all about just this type of guardianship, but this is the short version. Another type of guardianship that's in the new law is called standby guardianship. And I'm going to make a video about this as well. But short version is a standby guardianship is when the parent puts your name down as a future guardian in case something happens, like if they've been diagnosed with a serious illness, or if they're concerned that they may be deported or going to prison. They can do a standby guardianship and get it ready, and then it can be started when the thing actually happens. This is different from a parent putting you in their will as a guardian, which is another thing that they can do. But of course, that only goes into effect if they pass away. Okay, the standby guardian can go into effect even if the parent is still alive, but the thing they were planning ahead for happens. Okay, this is another one that is part of the new uniform guardianship laws. It's not in Article 2, it's in Article 1, and it's called Delegation of Custody. And it did go into effect in June 2020. So this is something that's important for kinship caregivers to know about, even though it's not the same as guardianship. Excuse me. So the parent signs a power of attorney form that grants custody or other parental powers, and it can be as long as 2 years. So it doesn't have to be 2 years, but it can go all the way up to 2 years. And on the form, there's a place to say how long they want it to be. You can find the form at washingtonlawhelp.org under the Family and Safety Non-Parents Caring for Children section. And the really important thing to remember about this is that the parent gives it, the parent can take it away. The parent can cancel it in writing anytime they want. So this is a good one if you and the parent are in agreement about you having temporary custody for a while. But this power of attorney it's not as strong as a court order. So that is important to remember. A court order can't just be canceled by you or by the parent. You have to take extra steps and go back to court to change it. So power of attorney can be canceled. Just remember that. All right. That concludes my very first video. I'm going to put this on the Kinship Care Legal Aid Coordinator YouTube channel. And that is where I will put more videos as soon as I make them. I really appreciate you watching. Hopefully this has been helpful. And I believe there is a comment section at the bottom of this YouTube video. If you have legal topics that you've been thinking about that are, related to being a kinship caregiver, feel free to type them into the comments and I will take a look. And if possible, I will research them and potentially do a video. I can't promise that I will do them for every single idea, but I am asking for your ideas and things that affect you personally. Don't type, personal details, but something like, what about applying for benefits for the child? Or what about housing rights? Things like that. All right. Thank you very much. And I will see you soon.